Welcome back to This is Live, the Sunday talk show, here on the Arise News channel. With me today, I have Yemi Adamalekun, Executive Director, Enough is Enough. I also have Achike Jide, a public affairs analyst. Now, the Supreme Court has affirmed President Bola Tinubu of the All Progressives Congress as a valid winner of the presidential election that held in the country on February 25. The Apex Court, in his lead judgment that was prepared and read by Justice Inyango Koro on Thursday, heard that there was no merit in the petition that former Vice President and candidate of the People's Democratic Party, Atiku Abubakar, filed to nullify the outcome of the election. It held that Atiku did not prove that the Independent National Electoral Commission, INEC, did not substantially comply with provisions of the Electoral Act in the conduct of the election. The Apex Court held that Section 185 sub 1 of the Evidence Act provided, and the Constitution, and also Section 185 sub 2 sub 6 provided that an election should not be liable to be invalidated when alleged non-compliance did not substantially affect the outcome of an election. It held that evidence contained in the record of the appeal showed that the appellants abandoned the duty imposed on them by the law to not only prove the alleged non-compliance, but to establish that failure of INEC to transmit results of the election through its iRev portal influenced the outcome of the presidential poll. The Supreme Court said it had in past judgments made it clear that there was a difference between the election result collation system and the iRev portal. Still on legal matters, reprieve has finally come for Nigeria as a London High Court on Monday upheld its suit challenging the bid by the Process and Industrial Development's P&ID to enforce an arbitration award that has accrued to $11 billion over a failed 2010 deal to develop a gas processing plant in Cross River State. In a judgment delivered by email, Robin Knowles, a justice of the Business and Property Courts of England and Wales, upheld Nigeria's argument that a gas processing contract was obtained by fraud. The court ruling brought to an end a 5-year legal battle to quash the arbitration award. P&ID claimed Nigeria violated terms of its agreement by failing to provide gas for the power plant it wanted to build for the country. The arbitral tribunal also unanimously decided that the Nigerian government had repudiated the GSPA by failure to perform its obligations under it, and ruled that P&ID was entitled to $6.6 billion in 2017. That fine, along with interest, has now risen to $11.5 billion, which Justice Knowles has now dismissed. To discuss these developments and other legal headlines during the week, I'm now being joined by a leading public interest lawyer, publicist, law reporter, and legal commentator, Jide Ogunye. Good to have you on the program. This is Live, the Sunday talk show, Jide Ogunye. Well, Jide Ogunye, thank you very much.
Thanks for inviting me.
Thank you very much for joining us. Let's start with P&ID, which appears to be a source of major relief for Nigeria. About a third of Nigeria's GDP will have been consumed if Nigeria had lost that case. Nigeria won. Even former President Muhammadu Buhari has said that this is a matter of principles and is claiming the credit for his administration. Spokespersons for the Tinubu administration are also claiming credit, saying that, oh, Nigeria has been saved. The issues involved are fraud to public policy. Now, what are the lessons that Nigeria can take away from this particular P&ID case that will have put Nigeria in very difficult situation?
Now, thank you, Dr. Abati, for inviting me. Your question is very important for every Nigerian, particularly those who are in position of government, who daily contract sovereign contracts with international organizations or national bodies on many things. Because the past is but a story told, the future may yet be written in gold. So for me, the lesson that we've learned, or the lesson we can learn, is very important. Because if we do the same things again tomorrow, we'll find ourselves in the same troubled waters, and then we'll now be clinging to a foreign jurisdiction for salvation. Now, that contract was a contract that had a noble objective, if you asked me. Forever and ever, gas flaring has been the blight of oil production in Nigeria from 1958 up to now. And the objective had been that this gas that is just being flared is money. And it has to be harnessed, and so that Nigeria can make the best use of it and make money from it. So the contract in 2010 between the federal government of Nigeria and the company, P&ID, gas, is Processing and Industrial Development Company, Processing and Industrial Developments Limited, that's the name of the company, had the objective to harness this gas. Nigeria is to supply what is called the wet gas. And the company, setting up its machinery and its structures and its facilities, would then refine the gas, having captured it, and turning it to lean gas, which would then be sold. But Nigeria ended up not supplying any wet gas, and the company didn't build any facility in Nigeria to harness the gas and turn the wet into lean gas. Now, the agreement hasn't been repudiated because nothing happened under the agreement. The parties went to arbitration, and the arbitration, there was an award in 2017 to the effect that Nigeria should pay 6.6 billion in damages for breach of contract. But then there was also an interest element of 7%, which translated to $1 million per day. And that's how we arrived at the 11 billion now. Now, the court looked at it and came to the conclusion, based on the submission of Nigeria, that that contract was a fraudulent contract. And that, there are three options under the procedure. Having so pronounced, the contract could then be returned to arbitration, so that the arbitration body could then have a reconsideration, if to have a reconsideration, or the court could then set aside or void the contract in whole or in part, or remit it to the arbitral body to also, in whole or in part, to also do justice to it. And so the court said it was going to set a date for that argument to be heard from both sides on what it was going to do to that agreement. But it had declared that it was a contract procured by fraud, and that therefore the contract was going to be treated the way the court said it should be treated. Now, the lessons that we can learn are many. The first for me is that the Nigerian government, the corporations in Nigeria, the government entities who enter into all sorts of agreements with foreigners who only come here with their portmanteau or portfolios and then say that they bring in investment and all that. Because too often we talk about foreign direct investment. We want money, we want investors. We have to be wary. Government business, it shouldn't be regarded as a no man's business. So it could be treated with levity, it could be handled with, unseriousness and negligence. No, those who handle this on the part of government must handle it as if they're handling their own personal contract, personal affairs, and that if they are to make mistakes or they are to be negligent in handling this thing, they could then lose money. So they should put themselves in the position of the government and do what is right by Nigeria. That's the first thing I would say, the first lesson. The second lesson is that, too often, Nigeria usually go into arbitration over matters like this. You recall, and Nigeria can recall the Bakassi arbitration, and Nigeria lost Bakassi and then lost to Cameroon. On that occasion, as a critique of what happened eventually, many Nigerians were wondering why Nigeria didn't go to the International Court of Justice with the best lawyer they could get. International lawyers from Nigeria, and then the one they could hire from abroad. Don't forget that this started, that matter really came to the fore during the Abacha years, during the military era, and so many people thought that, well, the military had a way of doing their own things and all that. So one of the lessons for me, therefore, is that as Nigeria will continue to go into arbitration, if there are disputes, Nigeria has a duty to put its house in order. Get the best brains they can get locally. It shouldn't just be job for the boys. Yeah, the Attorney General is there, so farm out briefs to his friends, and then they go to arbitration and then come out with something that all of us will be alarmed about and say, how did this happen? And so on and so forth. That's the second lesson for me. And the third lesson is that, look, just as we've gone to the UK now to receive reprieve and claim salvation, we must understand that our judicial system must be fortified to do justice. I looked at the sheer volume of the judgment, and here I am, I'm a Nigerian. The white man, that judge, was doing justice in his own country. He had no special reason to favor Nigeria. But if you look at that judgment, the adjudicatory labor that went into it and all that, that judgment couldn't have come from a court that is not well resourced in terms of facilities and all that you may talk about for justice to be quickly dispensed. Here is a judgment that goes into 140 pages, written in fine prose. Yes, legalese is there, but about 540 paragraphs, big paragraphs, meticulously done. And I was just looking at it. And I know that our judgments are not written like that here, but I was fascinated by how the judgment was written, the introduction, the body of the judgment, the trial, everything that was so meticulously done. And so the third lesson for me is that just as that court had given justice there, we must spend time on our judiciary and justice administration generally to ensure that our courts are able to give judgments, timelessly like that.
Okay, Jide, in that particular judgment, focusing on fraud and public policy, certain Nigerians were named. One of them now died for having perpetrated the fraud. Now, the court, being a foreign element forum, a foreign jurisdiction, did not specifically pronounce on penalties for those people. What should Nigeria do as consequential action? Because specific persons were named as persons who perpetrated fraud from the Nigerian side and colluded with others. Should they get away with it?
I don't think so. What they did against Nigeria, such persons, is subversion of our sovereignty, subversion of our interest, subversion of our national interest. And I think that anti-corruption agencies, particularly the FCC, should pick that judgment and then look at it and then make certain invitations. For some of the people that have died, I think that if indeed Nigeria lost money, and Nigeria lost money in this process, now we are talking about reprieve. But the truth of the matter is that there was a report that Nigeria spent over $40 million on legal fees funded through the CBN to get to where it's gotten to. So there is an economic adversity. There is economic, cost, that Nigeria had gotten as a result of this. And so, even for those who have died, I think there must be a way to make them accountable, whether it's their estates or so. Too often here, we just want to say that, okay, let's bygone be bygone. Those that have, certain eminent Nigerians even went to testify against Nigeria, during the arbitration proceedings. Nigerians, okay, in support of the company, that this court has now found out to be a company that brought a vehicle of fraud to Nigeria, to cause all this cost. So I support the idea that, yes, it's not going to be a tailist thing, that we are just, we are following what, if they didn't do that before, why are we now, following what they've said? I think that it's a matter, as a matter of public policy, a matter of public interest, that Nigeria should revisit to make the Nigerians, that are responsible for this kind of economic, adversity, to be accountable.
Okay. President Muhammadu Buhari said this is a matter of principle in trying to claim credit for how the, the judgment played out. He having been president at a time when the issue was there. The Tinubu administration has also tried to claim credit. Who should claim credit? And what kind of reforms should we see going forward?
Quite frankly, I don't think that it's a matter for chest beating by either former President Muhammadu Buhari or the new president, President Bola Tinubu. No. We should just, in a very sober manner, because it's an indictment on Nigeria, that we allow this to happen. Some of our officials, participated in this. And this is not the first time. We also had the Malabu thing, oil block, and all that. For how long will Nigeria continue to bleed because of official corruption or because of the way we've mismanaged our affairs? So I don't think that's a matter. We should just count ourselves lucky that, okay, we have a reprieve. So it's not a matter of taking credit. But if we are to be talking about credit taking, because government is a continuum, if it's about credit taking, a number of people may want to take credit. First, this contract in 2010 was, entered into when our former president, Musa Yar'Adua, was indisposed. So he was not in the country then. He was hobbled by ill health. And so the contract was signed. People were then scratching their head, who was responsible for this, who signed it, and so on and so forth. And later on, President Goodluck Jonathan, was the one who was there when the first discussion and arbitration went on, and the suggestion of $800 million, was put on the table to be paid so that they could go. He also had the good sense of not paying it. Perhaps because he knew that something was wrong with it, he pushed it to the Buhari administration. And now the Buhari administration also had the good sense to challenge it frontally. And President Muhammadu Buhari had the grace of having a professor of law as his vice president. Because you recall that when the matter really when the push got to shove, President Muhammadu Buhari was also not in the country. The vice president, as the acting president, was the one generating memo and saying that this is wrong. We can do something better. So there are enough people in the room to take credit for all this. But it is good that the Nigerian government, as a whole, realized that something very shoddy, something very dishonorable, something very dishonest had happened. Indeed, a fraud had occurred, had been perpetrated on the nation, as Vice President Ochibayo called it then, and they had the good sense to put all the resources they could put together to fight the matter. And then we're all lucky now to have this kind of reprieve from the United Kingdom.
Okay, Jide Ogunye, before I move on, I would like to draw your attention to the fact that while Justice Knowles of the Business and Property Court in London specifically identified certain persons who are villains on both the Nigerian side and the other side. He singled out Olashupo Shashure, SAN, as somebody who was, who was transparent in his involvement in the matter. Do you think that Nigeria owes Olashupo Shashure, SAN, an apology? Because, in fact, he had been harassed by the EFCC and all of that. And now the commercial court in London is saying no. In this forum, what we have seen is that Olashupo Shashure, in fact, acted well. What do you think?
Well, it is honorable when you have committed an error or done a wrong to say sorry. And I think that for Olashupo Shashure, Senior Advocate of Nigeria, with this pronouncement by the court, I think that you should just take it that professionally, you can also have, there are professional hazards. All professions have their hazards, and all that. And even in the legal profession, lawyers may be diligent, doing their best and all that. They may be accused of, procuring judgment from the court, and due credit may not be given to their adroitness or their excellence as lawyers, who have indeed worked for a good judgment. The other side, the losing side, may accuse them of, oh, we know how it goes, and so on and so forth. So they are professional hazards like that. And now that this has come, I think that the Nigerian government must look at that. I know that there are processes in court. There is a case going on in court now. I know that. I don't want to comment too much on that, but I know that certainly all this will be taken together. The new Attorney General of the Federation, Lateef Fagbemi, Senior Advocate of Nigeria himself, is just coming there, and so he has a fresh mind to look at all these things, and so certain amends can be made going forward, so that those who have been wrongly accused can then be, rehabilitated, and those who have now been found to be real culprits, but who are yet to be sanctioned, even though they be dead, something can be done so that justice will be done to the living and the dead. All of us deserve justice in this matter, so that we just don't say, oh, yes, now we are not paying anymore. You have paid, you have spent $40 million, you spend more, just to get to this stage, and then again, internationally, Nigeria has witnessed another embarrassment again, although we have a saving grace. Oh, that this is coming from Nigeria again, I mean, there are certain nationals who come to Nigeria, and when Nigerian officials suggest to them that, oh, this is the way we want to do things, give us money, bribe us so that we can give you this contract, they tell you, oh, we don't want to go to jail in our country, in our jurisdiction, because we'll go to jail there when we get back home. Because every money that leaves our shores, be it the United States or so, we have to account for it, what we did with it. And that's why many of those contracts now, sovereign contracts, you see a clause being inserted that, any money that you receive, anything should not be funneled towards corruption or corrupt practices. You see that. Okay. I'm not sure that that's what is done in other jurisdictions, okay. But I know that in Nigeria, in particular, the number of contracts I've reviewed that have those clauses about don't use our money for corruption. We are not liable, and that we are not going to be answerable to that and all that. Just as a safeguard and as a protection for themselves.
Let's go to the other case in Nigeria that has both local and foreign interests, which is the affirmation of the victory of President Bola Ahmed Tinubu in the presidential election petition. You just talked about justice being done. Do you think that justice has been done in that particular case? What's your take?
Well, I think justice has been done in that case according to law. You know, sir, that there are many notions of justice. Social justice, economic justice, popular justice, things like that. But justice in our courts is not justice in a vacuum. It's not justice according to the whims and caprices and unreasonable expectation of partisans or people who are the litigants. It is justice according to law. And what the Supreme Court did in this case is to review all our laws, the governing provisions, and to make pronouncement. As a matter of fact, for me, the Supreme Court, in deciding the matter, did not do anything extraordinary or profound. And I'm not saying this because I respect them a lot. They merely reiterated and restated all that they've been saying, including even stating that on the issue of double nomination of the vice president, we had dealt with this matter before, and the lower tribunal stated that the Supreme Court had dealt with it. So why are you now even coming up here to even raise it afresh again? So I think that the Supreme Court did justice according to law. And we can deal with all this issue, quickly, if you permit me. In deciding the matter, first, I wish to commend the speed with which the matter was decided. It could well be that some people say that they've made up their mind. No, not so fast. You recall that the lower tribunal delivered the judgment on September 6. And, notices of appeal were filed thereafter. And we're in October. By October 23rd, Thursday, they had delivered the matter. They had the matter on the 20th, Monday, and they communicated that date of delivery of judgment will be communicated later. And then, within the same week, they delivered the judgment. If you look at others, although there is no intervention of 180 days, then, by way of constitutional amendment, talking about Section 285 now, the Yaradua, the Buhari INEC decision decided in 2008 in respect of 2007 election, in part 1120 Nigerian Weekly Law Report, 19 Nigerian Weekly Law Report 1120 at page 247, was delivered in 2008, December 12th, from 2007. Okay, but here we had the Supreme Court doing that, so the speed was something that I noticed in this one. Then on the substantive issue, the Supreme Court, looked at all the issues. There are grants that were prolix, if you ask me, but certain issues were distilled from the grants, 7 issues, and they looked at those 7 issues and they decided the matter, one after the other. First, the issue of, not in the order in which they presented it, 25%, they dismiss it. The issue of whether you could bring in fresh evidence on appeal, they dismissed it, that you couldn't do that because they had no jurisdiction to do that. That in the lower court, there is 180 days to deliver, to consider and deliver judgment in the matter. And that from the date of declaration of results, you have 21 days to present your petition. And you can't amend that petition. You can amend it. Section 132 of the subsection 7 of the Electoral Act, married with paragraph 14 of the rules of procedure for the election tribunals, say that clearly. You can't amend. So everything that you put in, you have to sink or sail with it. And this point has been made ad nauseum. It's been made repeatedly, time and again. And so they merely reiterated that if you couldn't even amend your process, your petition in the lower court to bring in the CSU-related deposition from Chicago, how can you then come to the Supreme Court and say that under Section 6, under Section 22 of the Supreme Court, and so on and so forth, that you want to bring in fresh evidence here? And in any case, this fresh evidence you've also brought is not certified, it's not registered. So they dealt with that. On the issue of substantial compliance, Section 135 of the Electoral Act 2022 says that if there's substantial compliance, you cannot deal with that. And they also reference Section 185 to sub 1 of the Constitution and all that. That you cannot, there's substantial compliance, rely on the Evidence Act, Section 181 of the Evidence Act, and essentially, they looked at all these things and they dealt with it. IRF, they've stated this one before now. In the case of that emanated from Osun State, Oyetola and the Adeleke case, they also stated that one clearly, that IRF is not a collation portal and so on and so forth. So in sum, and on the whole, I would say that they did justice according to law.
Okay, I would like you to comment on the subject of jurisdiction. Jurisdiction. Akim Olaniyan, professor, yes, and Ayo Agbede in Conflict of Laws. They've told us that this is the fountainhead of the authority of the court in terms of applicable authority or law within a forum. But the court has mandatory jurisdiction. It can also assume the restriction, which is a discretionary jurisdiction, and it can decline jurisdiction. That's what the theory tells us. But in this particular case, they just declined jurisdiction. Now, couldn't they have assumed recognition, even when they say what came from the foreign forum was not registered, and hence not enforced, and hence not admissible? Were they right on that point of law?
No, the point you raised is a very important point. You know, jurisdiction has been stated by an eminent jurist, Justice Mohammed Bello of blessed memory, is the lifeblood of litigation. So it's like an animal, you know, once it's drained of blood, it dies. So a court of law cannot entertain a matter, adjudicate and determine it without jurisdiction. If it does, no matter how beautifully done the job is, it's like a waste of effort. Now, every court of law in Nigeria has the jurisdiction to determine whether it has jurisdiction. In other words, once the jurisdiction of the court is being challenged or being contested, the court is not robbed of the jurisdiction to decide by itself whether it has jurisdiction to decide the matter. And what the Supreme Court has done in this case is that the number of people who argue that the Supreme Court has inherent powers, inherent jurisdiction to, but it's like saying, where would the inherent jurisdiction, where would it lie? On the side of the Supreme Court to violate certain provisions of the Constitution. You will recall that in many cases, the Supreme Court had stated eloquently and clearly, quite luminously, that, look, part of their duty is not to legislate and then look at a provision of the Constitution and say, oh, no, 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 we want to fill in the gaps. They shouldn't have done this. And so once they are clear, once those provisions are clear, they only have recourse to a textual or literal interpretation, literal meaning, and give force to it because they interpret the laws. And so when the provision of the Constitution, Section 285, says this is the time limit, it's not even decided by case law. This is the time limit. We are talking about statutory provisions now. The court will be acting without jurisdiction to demolish those provisions and say, in the interest of justice or substantial justice, we have inherent powers to then decide whether we are going to bring in this or not. The Supreme Court, you know, in a manner of speaking, hands were tied by the clear court provisions of the law. And I think that the Supreme Court acted rightly and justly in this matter. The truth of the matter also is that, look, and less people talked about, oh, this a technical victory, this is a technical judgment. I don't think so. Others may have their opinion about this election. I've monitored the election in my life. The last one I didn't participate, I didn't even vote. But I've monitored the elections in my life, including the 1979 election, the pattern of voting and all that. All the parties that are complaining about the election also got their votes from the same election they are complaining. The 6.1 million, the 6.9 million, the 8.7 million, all of them got their votes from the same election. And so, unlike the 2007 election, that one of their justices, I think that is Justice is late now, you know, stated that it's a gungun of an election, that may Nigeria never have such an election again forever. It was clear that the Supreme Court, when dealing with the matter, realized that there was a problem, that the election was hopelessly rigged. And that's why we had that 3-4 split decision with Justice Oguntade, Justice Mokhtar, and Justice Walter Samuel Onoge, you know, dissenting with Justice Nikitobi, then tilting the scale, you know, when he then joined Justice Kutugi, Justice Mustafa, and Justice Katsina Alu to give victory to Yar'Adua. And that's why Yar'Adua came out to say that this election was flawed. Okay, you cannot say that with this last election, regardless of what anybody may say.
Okay, GT, we can be on this conversation for the next 1 hour. Too many issues to consider, but two quick ones that I would like you to just comment on briefly. The first one is, what advice will you give to the appellants who lost out, who have refused to congratulate Bola Ahmed Tinubu, and tomorrow we're told that Waziri Atiku Abubakar is going to have a world conference where he will react. Second is the valedictory speech by my Lord Justice Datijo Muhammad, where he inducted the, what you call the overwhelming powers of the CJN and, you know, the integrity, indeed, of the entire Supreme Court and judiciary. That's fresh material that came after the Supreme Court ruling in the Tinubu case. Briefly, so that we can move on.
Okay, quickly. I'm not going to advise anybody that doesn't want to congratulate the president to go ahead and congratulate. You know, the nice thing can be said about being gracious in defeat and magnanimous in victory and all that. Let's work together to build Nigeria and all that. But if somebody says that it's not going to congratulate anybody because of fixation, I think it's okay. After all, President Muhammadu Buhari, for years and years, was always saying that he won those previous elections, in spite of the fact that data didn't support that. You know, he had no national spread. You know, but he believed that he was rigged out in all elections and that he wasn't even going to a National Council of State meeting. You know, partly because he felt that they were robbing him of victory. So I'm not going to compel anybody to congratulate anybody if they don't want to congratulate anybody. Now, but it will be good if they believe they are statesmen and they know that there will be tomorrow, they can still contest election in the future, and it is nothing personal. They will be well advised to do that. But if they don't want to do that, that's fair enough. Now, on what the valedictory bile, that's what I call it. valedictory bile of Justice Datijo, I don't think that that statement was well intentioned. Look, he rose to become the number 2 person in the judiciary. Justice Ariwola, who became the CJ in a way by default, because the CJ who was there, had to resign. He claimed on health grounds, but we all know the story, so he had to resign. Now, all the issues that he raised about the judiciary, about the Apex Court, about the enormous powers of the CJN, all these issues have been discussed before. I had raised the issue before. Justice Salami had raised the issue before. When Justice Salami was being traduced, he raised the issue. Many Nigerians raised the issue about the power of the CJN, about how we have to have a different NJC in terms of its composition, so that the CJ will not be the CJN of Nigeria is the president of the Federal Judicial Service Commission, is the president of the NJC, chairman of the NJC, is the one who constitutes the body, and so on and so forth. So all those issues that Justice Datijo raised are well-known issues. But for him to then raise those issues again and then start pointing accusing fingers and talking about integrity, I don't think that he did right. If you want to be a reformer, even while you are still in the system, you could make recommendations, you could make suggestions, you could do certain things. He was talking about not being consulted. There are certain things that a CJN is not supposed to consult anybody on. For example, a CJN constitutes the panel of the Supreme Court to hear appeals and so on and so forth, just as the administrative judge in a division of the Court of Appeal, or the president in Abuja, where he's sitting. That's his prerogative. So if any judge is now insisting that he ought to be consulted before panels that will determine cases, then we must be asking, is there something that we should know that we are not knowing? Is there something that we should know that you are not telling us, because you are insisting on doing this? But overall, when you have this kind of situation at the Supreme Court, we also always worry. You recall, Nigerians can recall that at a particular time, there was a testy relationship between Honorable Justice Begori and Honorable Justice Wace, to such an extent that they granted interviews, they made certain accusations, and at a point, the office of the CJN was allegedly boggled, at that time. And so we had the one before Justice Ariwola became the CJN. So when these things happen, we worry. Of course, there are issues of principle that are interlaced, what I call as the valedictory bile. Yes, the issue of accountability, who guard the guards, the money being voted to the judiciary. Yes, there's judicial independence, but does that independence mean that they will not be accountable? They will not, be audited and so on and so forth. These are issues of principles, especially when we've been agitating for judiciary self-accounting system, that the money to be voted to the judiciary, to the heads of the courts all over the federation, that this money should be properly accounted for. Because judges are now being, portrayed as people who are handling money and so on and so forth. Yes, there are those issues of principle, but I don't think, on the whole, that what Honorable Justice Datijo, with profound respect, did. The forum that he chose to do that when he was leaving, and then he poured it all out, undermining his brother justices. I don't think that it's like a stab in the back. I don't think that that's too good.
Wow. Thank you very much, Jide Ogunye, for joining us. And I think the big takeaway for me is the point you made about who we got, yes, the guardians. Qui ipso custodis, quid custodiet. Who we got the guardians.
Yes.
Yes. Thank you very much for joining us.